There's a fundamental misunderstanding of what's going on in TBI cases, and I've seen it across the country. One of the big problems is everyone thinks that defense counsel is the thing lowering the value of your TBI case, and that isn't it at all. Where most lawyers lose value in the TBI case is not knowing what to focus on. Finding what to focus on, finding how to make your client's brain injuries real and no longer invisible is the thing we're going to be discussing today. And the sooner that you have a fundamental focus on exactly where it is that you need to spend your effort, you're not worried about defense counsel anymore. You're finally worried about the thing that will help your client the most. And that's what we're going to get into today, is the fundamental misunderstanding of TBI cases that is causing you to leave millions of dollars on the table for your client. My name's Taylor Ernst, 2024 California Lawyer Attorney of the Year, according to the Daily Journal. The Daily Journal is, for those in other states other than California, is the newspaper for lawyers by basically lawyers. They know everything that's going on. They track all the stuff. It's not one that you can buy. That's one that you have to earn. Additionally, I've taught over 20,000 lawyers and doctors in every state in the United States, sometimes small groups. Other times I've had audiences up to 5,000 people watching the single presentation that I'm giving. Additionally, got a $63 million verdict, and I've authored the book, The Ernst Way. It's a definitive guide to TBI litigation. It's what I wrote basically for what I wanted when I was a young lawyer. I have been there where it's the middle of the night. It's 1 a.m. I'm trying to read the research that they dumped on me the night before this deposition of this hard expert. It's what I wish I had when I was a younger lawyer. And so I didn't have to go through all this pain and not knowing how to do the TBI case. It's right there. Why TBI cases present a unique challenge is everyone misclassifies what a TBI case is. They think if you are injured and it just involves your brain, it falls under the same category of all the other cases that you do where someone's injured. They view it as just a personal injury case that happens to be a brain injury. I don't think that's right. When I hear other lawyers say something to me like, I don't do medical malpractice cases, but I'm doing this brain injury case, it's interesting because I view it as they're doing a more complicated case and they don't want to do the more medium complicated medical malpractice case, but they view them all as the same thing. And so it's one of the reasons that I want to give this information away to these other lawyers is I've been there. I've gone through the problems of looking at the client with the TBI who calls my office 7 times in a day because they can't remember their appointment, they lost their medication, they've got locked out of the house again for the 10th time in the last week. All of these minor issues that seem to make the client more difficult to deal with because of their brain injury are the reason the case is so significant. I take 3 to 5 calls a week from other lawyers saying, hey, tell me about your brain injury case. And the number of times some lawyer gets on the phone with me and says something along the lines of, oh, I've got this great brain injury case, but the client is so difficult, but the client is such a problem. This case would be really great except for this client. The reason the client is so difficult is because of their brain injury. That's what makes the case so significant. Internally, we think that we spend between 4 and 10 times more time, effort, hand-holding, having a paralegal or lawyer work with a brain injured client because they require that much more attention in order to effectively move their case towards trial in a way that they understand what they're doing. The deposition prep goes well. Everything just takes significantly more time. And another example is when you do deposition prep of clients, brain injuries are unlike anything you do in any other segment of this type of deposition prep. Because I'll hear lawyers say, oh, I prepped my client for 2 or 3 hours. And I'd say, isn't that the client that has the brain injury with the working memory problem? And they're like, yeah. I'm like, they're not going to be able to remember much past 20 minutes. Why are you setting up the way that you speak to that client in a way that really makes their ability to pay attention, listen to you, and remember the information more difficult? So to give you just a very tactical way of approaching how to prep a brain injured client, and there's a very long list of these, but this is just one of them, is if your client has working memory problems, don't do a 1 or 2 4-hour sessions of prep. you should do 20 that are 10 minutes long, and so they can actually try and comprehend and be able to get into their brain what's the best way to tell the truth at deposition. One of the cases that we worked on ended up being a pretty significant 8-figure result. I personally was like, hey, we need to do like 10 or 15 different calls, and they all need to be 5 or 10 minutes at max. It was one of the keys to success, and he told us afterwards, having all those tiny meetings where we went through the things again and again was the key to the success that led to the 8-figure result. So when I say TBI cases require significant more allocation of time, it isn't just the time that requires significantly more for the brain injured client, it's also money. That's another section we're going to get into, but when we say, hey, you need to spend significantly more time prepping the client, spending time with the client, figuring out how to make the invisible visible, it's because the client really does need that level of commitment in order to get the result that you want. So to give you an example of why certain TBI clients require significantly more time, attention, and just resources in general, I give my cell phone number out to my clients, and I had a client, all of a sudden it was like 6 o'clock on a Friday, and I got a phone call from the client. I answered, and it's like, why are you calling me? And she's like, the police are looking for me. I said, what? Say that, what? The police are looking for you? She's like, yeah, the police are looking for me. I said, why are the police looking for you? She's like, well, I picked up my daughter from school and I'm 3 or 4 hours away. And I said, what do you mean you picked up your daughter? And she's like, well, I wanted to go on this trip with my daughter and the court said I couldn't. And I was like, there's literally a court order that you do not have custody of your child. Did you tell anyone you were picking up your daughter? And she's like, no. I'm like, so your ex-husband thinks his daughter's just missing? And she's like, probably. And I'm like, that's why the police are looking for you. You need to turn around and drive back home. It's this level of judgment that sometimes will take a TBI case and absolutely blow it up, because the defense will love talking about kidnapping the daughter, having a fight with the ex-husband, and the ex-husband testifying against her and just saying she's difficult. Where we know from the scans and other things we've looked at that she has a brain injury that's impairing her judgment in a specific part of her brain, and being able to deal with it so she doesn't get a further arrest record is the type of thing that you think the client's just difficult. It's just standard for TBI cases, is where they make these judgment calls. Where another example is we had a client that all of a sudden took up gambling in the middle of the night. Never gambled in his life beforehand. After the TBI, after a number of months, his wife starts complaining that he'd get up in the middle of the night and gamble for 3 hours. And it's that level of impaired judgment, difficult things. If you don't start communicating with the client early enough so that you can deal with these problems before they metastasize, these will turn into problems that will ruin your case, because the jury will get the facts out of context of what a compulsive gambler they are. Or the one that really hurts in a lot of TBI cases is the client will start having a drug problem or an alcohol problem because of the judgment, that you need to get on top of that in order to get them the treatment, get them the resources, so that it doesn't become a defense talking point. And the reason I talk about these TBI clients as being so uniquely more time intensive is if you plan from the get-go, when the client becomes represented by your firm, starting to put these procedures in place where you have regular check-ins with the client, with the family, with someone you checking in with them, you can catch these before they metastasize in a way that will quite literally ruin the value of your case. Every single brain injury case that you're working on has one single fact, issue, problem that because of that, you aren't getting the value or the real value of what that case is worth. I know this because over the years, I've gone through this again and again and again on my cases and on the cases that other lawyers call me up and I consult with. It's become my mission to try and figure out a way to get this information to other lawyers to raise the bar of TBI cases. So with this specifically, every case has one big problem, one big constraint, one big limiting factor. I kind of view it as water flowing through a pipe, and all of a sudden there's a really big indent, or there's some big gap, or there's some big blockage, that if you get rid of that, it'll keep flowing through to get you the value that you're really looking for. To give you some examples of this is, I had a client that had an 11 millimeter lesion in his brain. And we're talking through getting ready, prepping him for trial. And shortly before he's getting on to testify for trial, one of the defense expert reports comes out, makes a big deal about how he was selling contraband to prisoners. He was a prison guard. And he was selling contraband to prisoners. And I'm like, oh man, how are we going to deal with that? And inherently you hear that type of fact and you go, yeah, well, that's a pretty big problem. Him selling contraband to prisoners, that's the kind of person a jury will not want to get behind. That becomes the constraint. That becomes the problem in that case. And so what we actually did is I went and sat down at his house and said, hey, let's talk about this. Let's figure it out. Because up until that point, I really liked him. I liked him as an individual. I liked his character. He seemed like the down-to-earth guy that you'd want to go to a barbecue with. And so I said, I just don't know all the facts. Let's find out what they really are. I sat down with him and started talking with him, and he said, oh yeah, totally. I did give contraband to prisoners. What they didn't tell you is it was cigarettes. What do you mean? Oh yeah, I'd give cigarettes out here and there. It would prevent fights in the quads. It'd prevent stabbings. It'd prevent people from having to go to isolation. It significantly reduced the problems that we had to deal with in our cell block because I gave away a handful of cigarettes. And I was like, oh, well, that's the story. And all of a sudden you take that constraint that you think really hurts the value of your case, and it makes it one of the factors that just doubles down on what a good guy he was. And so it's identifying where the constraint is in the case and then breaking it. And what's so interesting about it is sometimes it's facts about our client. Sometimes it's facts about the medicine. Sometimes it's facts about what is on scans. Lawyers will consistently also think a constraint is they'll get a report back from a CT scan that'll say no intracranial abnormality, or it'll say no acute intracranial bleed on a CT scan specifically. And what that means a lot of the time is it means there's no active bleed going on in the brain of the person who got the CT scan. And lawyers will misunderstand that as there's no brain injury. Brain injuries occur on a spectrum, and you can have a brain injury without a bleed on a CT scan. CT scans are actually very insensitive for what's called axonal shearing, and insensitive means they won't show anything. And so you can have a very serious brain injury and have a normal CT scan, and it becomes a constraint of the case where people think, oh, I don't have a good scan, and therefore I don't have a good brain injury case. Having a brain injury case where you can show a big picture of the scan and say, it's right there. 3 things. First, when you show them the little bleed on the brain to say, look, their brain injury is right there. The most overwhelming common comment we get from focus groups and juries is, look how small it is. Is it really that serious? Because compared to the rest of the brain, the one little dot that is the bleed does look small. And so they think having the picture is the magic bullet to proving their TBI case, and it's really not. The second thing that I think lawyers fundamentally misunderstand about using scans is it's a shortcut to prove significance, but it doesn't prove what you think you do. It literally is a picture, but then you have to explain what that picture means to a jury. And you are also going to have a defense expert that's going to make it as convoluted as possible and say it's normal as many times as possible in a paragraph. And so he's going to say normal 20 times and point to it a bunch of different times, and your expert's going to have to be explaining it as why it's not normal to the jury. You just end up fighting about a picture. The third thing that I think is a fundamental misunderstanding of being able to point to a picture and say, look, there's the brain injury, is it makes lawyers do less work on the case because they think the case is better. It's true. You can point to a picture and say, look, it's right there. And sometimes with certain intracranial bleeds, there isn't that much dispute that it is a bleed, but there is dispute over how significant that case is as a result. And so lawyers see it as the shortcut to instant proof when it's a piece. Do I think it's a big piece? Frankly, no. Because if I say, hey, I'll just do the example right now. I've got this brain injury case, and yes, there's a 5mm lesion on the brain, and let's say the parietal lobe. You have no ability to value that. You don't know how significant that is. You just know that there's a piece of data that you don't have any ability to put significance to. All right, now let's rewind a little, and let me give you the same case, same thing, with what I would call significance. Yes, we believe this client has a brain injury. Every Friday, he goes to Costco with his wife. And his wife, every single time they go to Costco, he says, honey, we should get those chocolate cake cups that are so delicious. And she's like, I don't think we can get them today. And then the jury hears the fact that she's been going to him with the store every Friday for 5 years. And they stopped selling those chocolate cakes 3 years ago. You can value that. You inherently know there's a memory problem. He's got a brain injury that's causing him to repeat himself over and over again. And the most remarkable thing about the wife is, do you know what she says to him? She doesn't say, hey, honey, you forgot. She's heard this story so many times. She just says, no, I don't really feel like it right now. When she tried the cakes 4 years earlier. And then when they stopped selling them, she realized he couldn't remember that. And every Friday, she'd have to tell him the same thing. Now, if you compare those two stories, you compare the story about what's on the scan versus the memory one of the wife, the memory one with the wife is way more valuable. They're the same case. And so that's the thing that it goes back to, what is the constraint that you're really trying to break? And when you think the constraint is the scan, is that really it? Or is it the significance you're trying to impart to the jury, and you just view the scan as the easiest way to try and shortcut the significance because it's hard to get the stories that you need to really prove your case? The number one constraint on any case that I ever talk to lawyers on is their belief in what the value of the case is. So let me break that down. Lawyers will ask me questions like, how'd you settle that case for $25 million? And I say, oh, it's easy. And they go, what do you mean it's easy? And I say, well, when they offer you 20s, you say no. And they go, oh, I never thought about that. The only way you can get the value that the case is actually worth is you inherently, as the lawyer, believe in the case enough that you are willing to turn down every offer that comes up until you either go to trial or settle what you believe the case is worth. And so, more than anything else, the fundamental constraint on most TBI cases is the lawyer who's working on them and the belief they have in the case. It's the reason that I get so frustrated, because I've worked with lawyers who's asked me to consult on something, and a couple of weeks later I'll see them somewhere and I'm like, oh, hey, how'd that one big case go? And they're like, oh, I settled it for $2 million. And in my head, I'm like, that case was worth 10, but they didn't have the belief that it was worth 10. And so when they had the offer that doesn't take care of their client for life, doesn't take care of all the medical bills they're going to need, but it sounded good enough where they weren't embarrassed to say, hey, I got this great result, they took it. And I think it's one of the biggest problems that lawyers have in the brain injury space is they don't have the conviction of what the case is really worth, and therefore the biggest limiting factor on all the things. You can talk about defense medical exams, you can talk about depositions, you can talk about bad facts, all that stuff. The biggest factor is the lawyer's belief. And I know this because when I was beginning in my legal career, I look back on some of the cases that I valued when I didn't know what I know now, and I went, oh man, I probably could have done better. The more I can teach you this medicine, teach you what worked for us, I think the better value you're going to get out of your own cases. And so when lawyers are like, well, how'd you settle that case for 7? Here's the actual tactical thing that happens. So let's say the lawyer's asking me, how'd you get 7? I said no to 5. And when I said no to 5, they told me, you're never going to get a better offer than this. This is trial authority. We're going to try the case against 5. And, oh, here's a report from one of our experts that calls your client a malingerer or a fraud, or it's all in their head and it's anxiety and depression. The reason the defense expert reports are so effective in reducing the value of what TBI cases are worth isn't because they're sharing new facts with the lawyer. It's they go to the fear of the lawyer themselves. And I know because I've gotten reports where I'm reading the defense report, I'm going, oh my God, this report hurts me. And it makes me question the belief I have in my client's brain injury. And the more I question that belief, the more I doubt the value of the case, the cheaper I'm willing to settle it for. And I have to go back to the things that made me believe in the case the most in the first place. And that inherent belief of what you believe the case is worth will translate into how you talk to the defense lawyer, how you talk to the mediator, and eventually how you talk to the jury. Because if you don't believe in what you tell the jury the value is, the jury senses it. They know. They know. It's the biggest reason that the jury, when you stand up and say, hey, I think this case is worth $50 million, the jury knows if you believe it or not. If you don't believe it, you're never going to get it. That's the reason that when I talk to lawyers and say, hey, the real biggest constraint I see case in, case out, and the biggest reason a lot of times they'll bring on trial counsel is they want someone that'll meet the client, understand the medicine, and believe. Like that's what you're solving for. It isn't the medicine or the experts or the paper workup, because that doesn't create the conviction that you need to get the value for your clients. So one of the other things that belief does as the constraint is it limits your ability to understand the value of the case and makes you more susceptible to defense arguments, mediator arguments, and just people around you of what you're willing to accept for your TBI case. Probably the second biggest question after a question about belief is, what is the value of my case? I get asked that so often that I probably should make an entire video or series of documents on how to value TBI cases. We have one internally. It's called the TBI case audit. The reason I want to talk about this is the defense or the mediator will say, well, the average settlement value for this type of TBI case is blank. I don't understand why lawyers aren't instantly upset by that, because I don't know, in every sport and everything I've ever competed in ever, if somebody would say, hey, you're 50% or you're in the middle of the pack, I'd be pissed. Like, I don't want to be in the middle of the pack. I want to be the best of the best. And so when the mediator comes at me and says, oh, the average value of the TBI case is 1.5 million. I'm like, great, I don't care. And he's like, well, don't you take that into consideration? I say, you just compared me to a bunch of average firms. We're not. Why would I pay any attention to that at all? If anything, that should be the absolute floor, bottom minimum limit that I'm not going to even consider. When they say, oh, hey, the comparables for this type of TBI case are blank, great, insurance company can do whatever they want. But as soon as you're willing to accept what the average is for your TBI case, three things happen. One, they will tell that averages to other firms because the lower they can get the average, the better. Two, when lawyers accept average, they internally are associating themselves with the middle of the pack, which you don't want to do, especially if you are working on these types of cases and want to raise the bar on them. And number three, more than anything else, is when the mediator or the defense lawyer uses that number, it creates a psychological effect known as the anchoring effect. We all know what that is. It's the number you throw out into the jury in the beginning of, I think this case is worth $30 million. It's the anchor that your number ties to the person's mind. And we do it to ourselves. And so when the mediator's first number is, well, the average case value is this, he's doing it on purpose to make you think that is the constraint of the case you're working on. And so how do you break through that? Let me get really tactical here for a second and just give you the secret that we use is the more specific you can get about classifying your injury, the fewer comparables there are. And so if you say TBI case, great. There's 1.6 million TBIs in the United States every year. You're comparing yourself to everyone from a mild concussion that resolves in a week to the people that have serious brain bleeds and coma. But if you look at the distribution of how many of those are, there's very, very few of the very serious ones, and there's a ton of the super mild ones. And so if you look at the average, of course it's going to skew low. And so what you want to do is you want to give the very specific diagnosis, as specific as you can, and then say there aren't comps for that. Because generally, there aren't. So when you say, hey, there's a depressed skull fracture with an intracranial bleed, there aren't a lot of comps for that because it's very difficult to find a depressed skull fracture in that exact area that you're talking about with your client. And so you are fundamentally flipping the script on the mediator when he's like, oh, I think it's 1.5. You're like, great, we're not average. You don't have comps on our specific type of injury. And they'll go, oh, well, this is the closest we can get. Great. Close and brain injury has nothing to do with anything because brain injuries, each one is unique. All the defense medical experts will say that. So just get them in deposition saying every brain injury is unique. Tell the mediator that and say, I don't care about comps anymore. Why are you giving those to me? Oh, and by the way, we're not average. So when we talk about the role of belief and understanding the fundamental idea that the biggest limiting factor of valuing TBI cases is ourselves, figure out a way to understand what makes you believe the case is so significant, and then figure out a way to transfer that belief to the mediator, to the defense lawyers, so that they understand where you're coming from, and then you'll start getting the real value of your case. One of the deepest problems in TBI cases is the amount of information that needs to be gathered to be able to understand the case is too low. And the reason is the traditional approach of any type of injury case is you meet with the client and you look at the medical records and then you value the case. That is old, outdated, and if you try and do a TBI case like that, you're doing it wrong. And the reason that is I know that's what I did. And that's the reason I could say I know I'm doing it wrong is because that's quite literally how I used to approach it. And the reason that's such a problem is you do not have enough information to make the stories that add the significance to the value. If I were to say one thing about the best way to significantly increase the value of your cases is you just haven't done enough work on your case. Why? Is if you look at the diagnosis in the medical records where it says post-concussive syndrome or dizziness or vestibular problems or eye problems or whatever it is that's the symptoms of the brain injury, symptoms are a single word that defines numerous stories that you don't know. In the book that I wrote, I talk about it as symptoms or signposts. Like the fundamental idea that if there's a word dizzy in your client's medical records, there are probably 10 or 20 stories about what that dizziness does, and you don't know them. And your client probably won't be able to tell them. And so it's one of the ones, if you ask your client, hey, can you tell me a story about being dizzy? They won't know. And it's the people around them, it's the way that you go about gathering significantly more evidence that became the framework that I think is one of the most powerful things for litigation and TBI cases in general. I call it the Ernst method of how you go about gathering facts. There's 3 circles. The furthest out circle is called gather. As you start moving towards the center, it's focus, and then it's reveal. And the whole concept is you go gather. If you have the medical records and just interview your client, let's say you have 5 pieces of evidence. If you go use this method where you go get significantly more information about your client from their coworkers, from their friends, from their family, from their garbage truck driver, from the lady they pick up dry cleaning with, from the crossing guard at the school, all of a sudden, instead of having only a handful of pieces of evidence, you all of a sudden have 100 pieces of evidence to choose from, and you can pick out the ones that made you believe your client. And so you end up with this whole enormous data to gather from that when all of a sudden you have that one medical record that says dizzy. That's why when you go to the client's house who loves eating Doritos and you look at the hallway with the white walls, all of a sudden you see orange streaks along the walls. And it's because the client eats a bunch of Doritos and then walks down the hall and has to touch the hallway with their hands as they're walking down it. And his wife's always having to go, oh, you've got Dorito dust on the walls again. And like, that's her complaint, but it doesn't build the dizzy story until you understand the depth of, if he's doing that at home at somewhere he knows and he's lived for 30 years, what's it going to be when he's in a new place, going to a new doctor's appointment? Doesn't that seem like he might be a fall risk and a danger for himself or his wife and the care that he might need in the future? All of a sudden you take a story with one single word in the records that says dizziness, and you start understanding there's a much deeper, more meaningful, more impactful story that is just waiting to be told. So when lawyers think they have evidence or gathered evidence about a TBI case, more often than not, what they have is a single definition or a single word that collapses a whole bunch of stories into something that's generalized. So talking about memory, it'll say client has memory problems, and that's what will be in the medical records. And the lawyer then, who's talking to me about like, hey, how do you value this TBI case? Or do you want to try it? Or how can you help me? We'll say something along the lines of, oh yeah, the client's got memory problems. And I'll say, what kind of memory problems? And they'll go, I don't know. And in my head, I'm thinking, is it working memory, long-term memory, short-term memory? You know, what is it? Because you can have missing memories for a variety of different reasons in the brain. Is it the fact that they can't record the memory, make the memory? Or is it the fact that they can't retrieve the memory? Memory is actually a pretty complex thing, and depending on the brain injury they have, it could be any of those. And so, not to discount with the lawyer, because frankly, I remember being at a point in my career when I'd say, oh, memory problems, and that would be all I'd know about it. It came from learning this, but what the core idea here is, when you see a medical record that says memory problems, that doesn't do anything in terms of moving the value of the case to being able to tell a defense lawyer, a defense adjuster about it, because they don't know how to value that. I mean, they say they do, but they don't. And what you're trying to actually do is figure out why it's significant. Why is memory problems significant to the day-to-day life? So let me give you 2 examples of memory where you can see what one's more significant. The first one is a woman who had memory problems, and the doctors are saying she needs help at home and she has memory and difficulties with certain parts of her daily life as a result of her memory. That's one case. Here's another case, is the woman was telling me she had memory problems. And then I finally talked to her son. And her son had come over for Thanksgiving and said, oh, I went over to my mom's house and she wanted to go get ice cream from the store. And we're like, Mom, you really shouldn't drive. And she's like, don't worry, it's only a block and a half. And she got in the car, drove around the corner to the store, drove back, and she comes back in and she's bringing a couple things from the store. And the son's like, well, where's the ice cream, Mom? And she's like, oh, I must have left it in the car. And so the son walks out to the car, opens the car door to get the ice cream, and he sees a sticky note on the steering wheel that says, remember to turn off the car. And you hear that and you immediately have your brain collapse the story and go, oh my God, she's driving places, not turning off the car. She probably shouldn't live alone. She probably shouldn't be driving. She needs some help around the house. And now compare that to the first story of the medical professionals. It's like, hey, this woman has some issues. They're the same person. And so when you see how much more information you can gather and organize it into a way to not say, oh, she's got problems with memory, but to demonstrate it on such a fundamental level through the family member, it's an order of magnitude difference. It's the difference between $1 million verdict and a $10 million verdict. And it's the thing that if you fundamentally set up how to gather more information about your clients from the get-go and not just look at the medical records, it just devotes significant more resources to every case. It's the reason that if a lawyer says, oh, I have 100 cases, I'm instantly like, well, they can't do TBI cases. Our office generally will have between 5 and 10 cases per lawyer, because if you have this level of commitment that you have to make for a single client, it's the only way you can do them the type of value that they need to get the resources, to get the value of the case that they're looking for. So one of the interesting things about working on brain injury cases all the time is sometimes I take the medicine and the tools that I learned from working on the brain injury cases themselves and apply it to myself. One of the concepts that you really need to understand is cognitive load. It's the reason that phone numbers are 7 digits. If you give a phone number of 805-4721, that number you can put in what's called your working memory. And if somebody says, hey, repeat that number back to you, that is about the limit of a working memory that you can have. Working memory only works as well as the cognitive load allows. If all of a sudden there's a bunch of flashing lights and music and sounds and clinking and a bunch of other things going on, and then you try and remember 7 numbers, it's harder to do because the cognitive load, what your brain is trying to do, isn't any longer just trying to remember the 7 numbers. It's trying to remember the 7 numbers and hear the 7 numbers and block out the lights and block out the distraction and focus on the voice that's telling you those things. That inherent concept is called cognitive load. Now, when it comes to brain injured people, their cognitive load is reduced. So their ability to use their mental horsepower to achieve things is lessened. It's the reason that they will sometimes do things that are a little weird. Like in restaurants, they'll be like, oh, it's too loud in here, and they'll want to wear earplugs. Or when they're sensitive to bright lights, is they'll be somewhere, but they'll be indoors, and they'll be like, well, I'm going to put on some dark glasses. It's those types of coping mechanisms that show you in a way that you can understand that the client who has the brain injury is trying to come up with roundabout ways to deal with their cognitive load. And more than anything is when you're talking to those clients, you want to reduce the cognitive load as much as possible so they can understand what you're communicating to them as well as you can. To give you an example, we had a client a number of years ago that every time she had significant cognitive load, as you'd make her do more than one thing at a time, she would stutter. And her stutter came out when she had to remember something or had to think about something or had to do anything that required more brain work. That's when her stutter would start. But if she was just doing things that were easy for her and she didn't have significant cognitive load, she wouldn't stutter. And so one of the ways you can demonstrate this to defense lawyers, adjusters, other types of people that you want to understand the significance of your case is you can try and put demonstratives together for cognitive load to show how the client's horsepower in their brain has been reduced. And when you do that, you are trying to figure out one of the biggest ways to transfer information of why the case is so significant. Because if you can do less with your brain, it affects every single area of your life. It affects your ability to hang out with your loved one. It affects your memory. It affects how you speak with people. And so all of that combined ends up being one of the largest things that people don't really even look for because it's not in medical records a lot of the time. There's some specialty tests that'll start showing up in, but for the most part, if you're just reading the medical records of your client, there's no record that says cognitive load. There's no record that says reduced cognitive load. It's something that all the medical professionals know about and will talk about, but it's something that you need to find very demonstrative ways. It's the reason we talk about gather, focus, reveal, of gather significantly more information about your client so that you can be able to get this specific points of data and then pass it on. The other thing is when you're dealing with specific points of data and how to pass it on, is the more specific you can get. You never want to write a brief or try and tell a story or have the witness testify off the witness stand of, oh, I have problems with cognitive load. That's actually something that I'm going to go on a tangent here for a little bit. It's one of the biggest mistakes I see trial lawyers make is they will try and convince a jury. Everyone says, oh, you tell stories, but they'll try and convince a jury with a bunch of general, oh, dizziness, oh, fatigue, cognitive load. They'll use these big words that to the jury, they don't mean anything. It's the memory example we gave earlier. Memory versus the sticky note on the steering wheel. It's a wildly different approach. And once you start making your stories specific, you gather way more information, you focus it down, and then when you reveal the story in a way that makes a significant impact on the listener, they're going to remember it for the rest of their life if you do it right. To give another example about cognitive load that just from a very tactical point of view you can use in your daily life is if you're doing a deposition or even so more at trial. One of the things, we actually have a person in our office that helps set up our trial. Quite literally the job is to reduce cognitive load as much as possible. And so when we show up at the hotel we're staying at or wherever we're staying, the printer's already organized, the paper's already there, we got extra ink, we got extra stuff, the Wi-Fi's already set up, we already got snacks. The whole concept is we aren't showing up and being like, oh, we got to plug in the printer ourselves, and why doesn't this work, and I can't connect to the internet, and the internet doesn't work at all. Getting rid of all those cognitive distractions so we show up and say, what is the one big thing we need to get done today to move this trial forward? Significantly allows you to operate on a higher level and use your brain power for the things that actually are going to make a difference for your client. One of the biggest ways that cognitive load is lost is not finding things and not being able to find things. The number of lawyers that write stuff down on a yellow pad, and let's say you just write 10 pages of notes on a yellow pad, and then you stick the yellow pad in your briefcase. And then later on, you're like, oh, I wrote down that really important concept. It's on the yellow pad. Then you got to open the yellow pad. You got to find the yellow pad. Then you got to open it. Then you got to figure out what on the 10 pages it was and where it was. And then you got to read your own handwriting. The ability to be able to access information quickly is one of the biggest problems that I see in trial by other lawyers. And I know this because I used to have the same problem, is you want to have a system that makes it as easy as possible for you to get all of the information you have on the entire case all into a single place that's easy to search, and everything you ever have related to the case goes there. When we have clients that have problems with cognitive load, not only do we need to understand what we need to communicate about their problems, but we need to look at these secrets that we learn for ourselves and figure out to say, hey, if I'm having issues where I'm always super stressed about this, this, and this, figure out a way to put a system in place that gets rid of the cognitive load. It's the reason that when we systematize our trial setup, it's so powerful, as we've done trials so many times where our systems are so good that when I tell other lawyers, oh yeah, usually when I'm in trial, I'm in bed by 9:30 or 10 o'clock every night, they go, how? Aren't you up till 2 or 3 in the morning? No. If we set up our systems right, we should never be up at 2 or 3 in the morning. All the work should be done ahead of time in a way that if you look at the delta of losing sleep, being stressed out, and not getting a good night's sleep, that is so significant to your mental performance the next day where the judge throws you a curveball and you can deal with it, versus if you haven't slept well and your systems are all messed up, or you don't have systems and everything's just scattered all over the place and you're just doing the best you can and trying to wing it based off of your experience. I've been there. It was awful. I had a co-counsel one time trying a case there was a medical emergency and the lawyer I was trying the case with all of a sudden had to leave. And all of a sudden I was by myself in a hotel room doing 5 to 6 witnesses a day with no help. And the biggest takeaway I had from that is my systems weren't set up correctly. Like, I need to never ever do that ever again. I want my cognitive load to never get that high, and I want to have backups on backups for my trial so that when I have the 5 witnesses prepared, even if the other person disappears, all I'm doing is showing up and executing. Is because I've reduced the cognitive load so that I can do the one thing that's going to move the needle with the jury. So the reason I'm talking about cognitive load in the previous section is you want to reduce the cognitive load for both your client and you as much as possible, and it's what actually gives rise to systems. And systems are something that our law firm's been using for decades, that you really need to understand the purpose of the system is to make it easier for you to get the stories out of your client. As we've been talking throughout this video, there's all this information of all these different symptoms and stories and how do you do it. We've made it easier for ourselves because we have to do it over and over and over again. And so we have checklists that I created because I was frustrated, and you've seen checklists be given out about TBI symptom checklists or some other types of things like that. We have our own. Feel free to ask for it. We'll give it to you for free. We just want everybody to use them so they can do these cases better. And the interesting thing about the TBI symptom checklist is I made it because I kept having clients be 6 weeks out from trial or 3 weeks out from trial tell me new brain injury symptoms that they didn't know about. And it was an awful experience for me because there was a client I had that had a brain bleed. All of a sudden the client told me, oh, I have double detached retinas and had surgery in it. And I was like, what are you talking about, double detached retinas? That's not in your medical records everywhere. He's like, oh, it's just my eye doctor. It's not related to the brain injury case. I was like, how long after did you have eye problems? He's like, oh, like 2 weeks. I'm like, what? Why wouldn't you tell me about this? He's like, I didn't think my eyes were related to my brain. And I was like, oh, goodness gracious. That, of course they are related. The brain is 60% dealing with vision. And so when your client has eye problems, they generally will be related to the brain injury in some way. And the reason I started making these checklists of, dizziness, eye problems, fatigue, all of the stuff is the brain is the conductor for everything we do in every aspect of our lives. It's related to everything. And so you need to have an understanding of all the problems the client has, because you can actually make cases about specific subsets of symptoms that are the most difficult for the defense to disprove, especially if they're the most significant. The defense a lot of times will over-index on anxiety and depression because 60% of the American population has had a depression diagnosis in some way. And so they love talking about depression because everybody has it. And sometimes there's some overlap with some brain injury symptoms. And so if the client has depression, they can say it's depression and it will require 4 weeks of therapy or 6 weeks of therapy and it'll be better. It's the cheapest thing for them to go to, where depression doesn't cause eye problems. And so if your client has eye problems, if you got symptoms of eye problems and can objectively prove the eye problems are related to the brain, all of a sudden the defense argument evaporates. So that's the reason that I made this checklist, is it reduces the amount of time that when I'm in a meeting with a client, I don't have to say, hey, tell me about all your symptoms. That's a terrible lawyer question, by the way, and asked by defense lawyers in Depot. It's deliberate. The reason they don't want to ask about each specific symptom is it makes the case bigger. And if they just ask, hey, tell me every symptom that you have, it's hard for a brain injured client to answer all the symptoms they have. They'll answer 3 or 4, and then the lawyer goes, great, that's the only symptoms you have, and moves on. Whereas if you have a symptom checklist and you can get the client to understand that they have brain injury symptoms that involve 15 different areas, it makes it easier for you not to have to do such heavy mental work to understand the significance of all the different areas your client needs. Additionally, it goes to the workflow of, if you have a good understanding of the symptoms that your client has, you can figure out what specialty doctors they might need. For example, if they have problems with sleep, a lot of times it's related to a brain injury. They can go see a specialty sleep doc. Or if they have problems with their eyes, they can go see a neuro-ophthalmologist. Or if they have issues with their balance, there's a bunch of testing that can be done for that. And so you can take the symptoms, and then you take the symptoms and you can look for objective tests and findings and specialty areas that the doctors then can use to document those symptoms in a way that makes the evidence significantly stronger. One of the other checklists that we made to make it so we didn't miss anything was a lot of times when you have brain injured clients, you have vocational experts that talk about what they could have made if they didn't have this brain injury, or some of the limitations that they have at work. And people generally all know about, a lifting limitation of 20 pounds or 5 pounds or whatever it is. But one of the ones that I think are significantly not talked about, that need to be talked about more in the context of brain injury cases, is all the different cognitive tools that can be used at work. Memory aids, sticky notes, calendar invites, all of those things. You need to have a checklist that you go through and are able to give this information to your expert, or have your client understand when they all of a sudden, the story you have is you have a client that had a perfect memory and they helped run a bike organization that had 50 members, and all of a sudden they get hurt, they get a brain injury, and all of a sudden they can't be part of that organization anymore. And all of a sudden, instead of having one person replace them, there's like 4 people that each of the 4 people takes a different job that one person was doing. Look at all the cognitive work they were doing, and all of a sudden they can't do it anymore. Or you'll have another situation where somebody has a really great memory and they just did everything in their head. All of a sudden, after they have a brain injury, they find sticky notes on the refrigerator, on their whiteboard, on their office desk. All of a sudden has 20 sticky notes of 4 different types of colors scattered all over the desk and all over the monitor. It's because of their memory problem or their retrieval problem that is leading to that. And so you want to be able to get this information all on a single sheet that you can then use to figure out what's the best way you can put on the loss of earning claim or the inability to work claim. Give you another example is we had a client that was working on a construction site and a 7,000 pound beam fell on the roof of his cab. Some chains snapped and the beam fell over and crushed the cab. He had 2 skull fractures and a brain bleed. And 3 months after the injury, he did a bunch of rehab. He was back at work, and he was somebody that defined his life by work. And they had problems. They first tried to put him on one thing, and then they tried to put him on another thing. And they kept trying to switch his job because he didn't have a good understanding of what his limitations actually were. Where if you can provide this information to your client ahead of time and say, hey, here's the problems that you're going to have in a day-to-day of work, and the one that everyone leaves off that should be discussed in every single TBI case everywhere is, can they work 40 hours a week? Or if they're working 60 or 80 hours a week, can they still do that level of work? Because a lot of times, because of, as we talked about earlier in this video, the increase of the cognitive capacity or cognitive load, their mental horsepower is significantly reduced. Somebody who looks fine, can still drive, can still do a lot of the work that you'd expect them to be able to do, can only do the 20 hours of work instead of the 40 or 60 they were doing before. And if they're only doing 20 hours of work, they're only doing half the amount of stuff. Isn't there a loss of earning capacity there of half? Where the defense will say, well, they're still working, they're still making a paycheck. Great, but for how long? And if they lose that job, do you think they'd be able to be employed in a competitive labor market? With how difficult it is to get and hold jobs nowadays, it's something that resonates with the jury that I think you need to pay a lot of attention to. And so this is another checklist that we made, and I made personally, because I kept having problems where the client would tell me about some new symptom that would affect them at work. And so take the shortcut, reduce your mental load, use the checklist. Use this and make your TBI cases better. So the next checklist that we made for our internal use is activities of daily living and independent activities of daily living. People will have problems if they're very seriously brain injured. They won't be able to do stuff like feed themselves or get out of bed, or what's called transfers, is go from a sitting to standing, or when they are standing and they need to lay down in bed, it's called a transfer. Sometimes you'll have attendant care to help with that kind of stuff. But there's a whole other subset of parts of daily life that are missed, which activities of daily living are the more basic ones. They are feed yourself, dress yourself, being able to brush your own teeth, that kind of stuff. Then there's what's called independent activities of daily living. And these are the things like being able to manage your own medication, finances, drive, being able to clean your own house in a way that allows you to not look like an absolute and total slob. These are things that a lot of brain injury victims have problems with, that they are embarrassed to talk about, they don't want to talk about, and they still try and do them. And so if they ask, can you do this thing? The answer is yes. But can you consistently do this thing the way you were doing it before this injury? The answer is then no. And one of the other ones you should look for in brain injury cases is brain injured clients, because their memory problems consistently will light things on fire. They'll often get banned from the kitchen or cooking because they literally almost caught the house on fire, or they'll leave a barbecue on, or they'll leave the stove on, or they'll absolutely, I had a trial one time where the client tried to make tea and he put a whole pot of boiling water on the stove that was inches deep, and he forgot about it so long that it evaporated all the water and ruined the pan. That's the kind of stuff that when you are talking about activities or independent activities of daily living, this checklist doesn't just do, can they do it? Yes, no. It's can they do it? Can they do it with pain? Can they do it independently? Do they need cueing? That kind of information is very helpful to not only your client, but the experts that then work with your clients. We talked about 3 different things so far. We've talked about TBI symptoms, we talked about work restrictions, and we've talked about ability to care for oneself in the home. Those 3 types of checklists are something that are super important, because what the standard practice is, and it's just a carryover from non-brain injury cases, is you have your client go see an expert. We complain that our client has memory problems, and yet we send them to an expert, and we give the expert some medical records, and then we let our client who has memory problems talk to the expert about all their issues. What do you think the likelihood is that they forget all the problems that they have? It's extremely high. And if you don't have the ability to give information to your expert in a way that captures every different problem your client has, they're going to ask your client, how do you do around the house? And your client will be like, I'm fine. And then a month later, couple weeks out from trial, you'll be talking to your client and you'll be like, oh yeah, I almost burned down the house again and the smoke alarm went off because I caught some muffins on fire. Did you tell the expert about that? Oh no. Why? Oh, I didn't think I was having those types of problems. And so being able to use the checklist to give this information to your experts is something that's so valuable, that is again and again made the mistake of, your client has memory issues, and yet you send them to talk to somebody that you paid thousands and thousands of dollars to evaluate your client, and then you're relying on your client's memory. It's just crazy. You do not want to do that. You need to figure out a way to transfer the information to your experts and give them additional records that show all the different problems your client's having in all the different areas of their life, that makes it easier for your expert to get it right. Because it is the truth. Use our mistakes. Use all the pain we went through. Use the checklist. It'll save you a ton of time, effort, and help your experts get it right. So one of the next things that happens in just about every TBI case is there's usually some bad fact that you're like, oh man, what am I going to do with this? More often than not, if there's a bad fact after your client suffered a TBI, it's related to the TBI. Not always. There's definitely circumstances where the bad fact is just the client not being a good person for some reason. But a lot of times the bad fact will be directly related to the TBI in a way that if you know more, if you gather more and follow the framework that I talk about, gather, focus, reveal, you can deal with the bad fact. And the best way to deal with bad fact is belief. Now let me break this down into an example of exactly what I mean here. For example, I had a client that suffered a brain injury and he lost 80% of vision in his left eye. And that was how he was for almost a year and a half. Couldn't see almost anything out of his eye, and he had one little area you could see a little bit, but that was it. He had some other problems that were going along with his injury, but his number one biggest complaint was he couldn't see out of his left eye. And then he was doing therapy and his eye got better. And I can remember the exact moment I had where I'm sitting in my office and another lawyer walks in and closes the door and he goes, what are we going to do with this case? The biggest complaint, the biggest driver of damages was he couldn't see out of his left eye, and he got better. Not a little better, 100%. You could see out of that eye again better. And I remember talking to the lawyer and saying, this is a bad fact, but only in the context of we do not have enough information about the bad fact yet. And he said, what do you mean? He couldn't see out of his eye, now he can. I said, well, if it's a brain injury, it was just the biggest symptom. I wonder if his other symptoms are still there. And we gathered a bunch of information about it and found out that while his eye got better, his balance was still a problem. His memory was still a problem. His ability to, he was a plumber, his ability to do certain things on the job site, jobs, running his own plumbing company, he just would say, oh, that's too complex for me, and refer it to his competition. This type of behavior over and over again led to us setting up a brain injury case by telling the truth in a way that was so compelling. I think the verdict was $5.65 million against a zero offer. The defense offered nothing. They're just like, we don't believe the guy. He's not that hurt. And we said, if he was faking it, why would he pretend to be blind in one eye for a year and a half? And to get into the details, to show you what the storytelling could do using the gather, focus, reveal method I've already talked about in this video, we found out that he built his house from scratch. The only thing he didn't build in his house was some of the electrical, which he wanted some help of an electrician to do it. The rest of it, he poured the foundation. He built the walls. He put the windows in. He did everything to build his own house. And then after this brain injury case, we're at his house and we're talking with him and we're talking with his wife, and we saw a workbook on his table that was math for second graders. And we're like, why do you have a math book for second graders? He's like, oh, I'm trying to teach my grandson math, but I have trouble understanding it now. And so I do the workbook before he comes over. And so you have the story of the guy who built his own house and did everything falling to the level of second grade math. That doesn't exist in medical records. And to have a guy who can't see out of his eye all of a sudden have that level of cognitive impairment, you can see why we got the verdict that we did. And so the reason I talk about this is overcoming bad facts with belief is you can watch the story that we went through where he couldn't see out of his eye, and we think, oh, the case is over, there's no value to it anymore, to doubling down and saying, this is just him trying hard to get better. Look at how much his life is still significantly impacted by this brain injury in a way that it makes absolute sense why we believe he's so brain injured and why the jury did too. Now, another way to overcome bad facts that you have about your case is reframe them in a way that you understand where the defense is going. The defense only has so many ways they deal with every item that ever comes up in a TBI case. Frankly, we have an internal list of every time the defense is going to put forth a new argument that we haven't heard before. We write it down, and we stopped doing that 4 or 5 years ago because there hasn't been any new arguments. They keep coming up with the same thing again and again and again. One of the most common ones I'm going to teach you how to address right now, just because it's something that's so common, it's in every TBI case that's ever worked on, is the fight about loss of consciousness. They always will say, oh, how do you know if you lost consciousness? Or the records will say they did or didn't lose consciousness. But let's get really tactical for a second. If you ask someone, did you lose consciousness? They're unconscious. They don't remember. There's a very difficult way to understand whether someone lost consciousness or not, and it's generally tied to memory. And so the only way you know if you lost consciousness or not is you have a missing memory. And the other thing that happens most of the time is because our brains are inherently storytelling machines, is we want to piece together all the things that happen to us, that we will, even if you do lose consciousness, people will ask, well, what happened? What did I do? What happened? And they try and put the pieces together that they'll say, I've had clients that have been unconscious for hours and hours, think that they weren't unconscious for anything but a brief period of time. And the only reason they realize they were unconscious for hours is someone else told them. And so the way to deal with it is, number one, is loss of consciousness is only one piece of information on how severe the TBI is. And talking about that in general, the defense always likes to call it, oh, it's a mild TBI because a loss of consciousness was under 30 minutes. That's only according to one of the standards. If you really want to get into it and you have debates about the standards, there's multiple ones. There's the Department of Defense, there's the Veteran Administration, and then there's the 2023 ACRM, which talks about mild classifications of TBI. And depending on the standards, they each come out with different outcomes. And then you have experts do their own thing where they say, well, based on my training experience, I think this was only a mild concussion or nothing. And what do you base that on? Well, my training experience. So because there's so many different standards, when you come back to loss of consciousness, the real focus shouldn't be, did they lose consciousness or not? It should be, was there altered mental state? And that's the key, is if your brain is interrupted from a neurological point of view enough to realize that it wasn't recording correctly, or that you weren't responding properly, that is the gold standard for what you really want to focus on. And most of the time, the worst person to get this information from is the client themselves. And if you just look at the medical records and just talk to the client, that's the information you're going to get. And we had a case that this year that we actually took from low 7 figures to 8 figures by finding a witness that came to the scene, saw our client who obviously said, I don't know if I lost consciousness or not. And there was a witness that came to the scene and did the medical thing of what's called a sternum rub, which causes pain to someone who's unconscious. Glasgow Coma Scales fought over a lot, and it made his Glasgow Coma Scale, when he said, I don't know if I really lost consciousness, of 15, which was reported 45 minutes later in the ambulance, to on scene, he had a Glasgow Coma Scale of 5 to 6. Meaning he had a severe brain injury instead of a mild brain injury. And we crossed with that with the defense experts. And even the defense experts were like, well, if that's true, it's a severe brain injury. And all of a sudden, the case 5x'd in value. And so it's the way that you can gather additional information. And if you know the specific thing you're looking for, you can quite literally, the example I just gave, 5x the case, 20x the case. But you have to know exactly what it is you're looking for in order to break the belief in yourself and be able to transfer that broken belief to the defense lawyers in a way that their own experts are like, I'm not sure we can fight the severe brain injury anymore. Like, this is something that we can say on paper, oh, we're disputing it, but internally, like, we need to value this differently. So one of the things that I know that inherently I used to do is anytime I got a quote unquote big case, I'd want to do it. Early on in my career, we got a client who had mesothelioma. And I remember talking to another lawyer in my office and being like, shouldn't we do this case? We can really help them. And the lawyer asked me, he's like, do you know the levers that are going to make that case really significant? Do you know the traps? Do you know the pitfalls? Like, if you make a mistake on this is their life. You need to refer it to somebody that does nothing but mesothelioma cases in order to make sure that person's taken care of. And the more I've advanced through my career, when I started telling or hearing other lawyers say, I don't do med mal, but I'm working on this TBI case. You either need to get the resources as a TBI lawyer and become the lawyer for the client, or you need to figure out a way to team up with one or work with one that can give you those resources, that's been through the battles, that knows where the levers are. Because when I hear lawyers settle a case for $2 million, they a lot of times will say, oh, I got this great settlement for $2 million. And then they start telling me the facts of the case, and inherently I'm like, that's worth 8 or 10, or that's worth 15. And it's easy to settle a case for $2 million that's worth 5 or 10 times more than that. It's hard to settle a case for that amount when an average lawyer would settle it for 1. But that context is most often not provided because they'll just give you the one data point of this is what the case is settled for. Where what you want to do for your client, for both taking care of your client and for your economics of the firm, is you want the most specialization you can get that is niche as possible, because they can shortcut all the problems that will cause the loss of value and the constraints that are put on the case. Just like we know in TBI cases, a lot of the time, if it's a severe TBI where there's a brain bleed and they have a feeding tube, the fight isn't over the brain injury. It's over whether there's nursing care or if it's just a non-licensed nurse that's going to be attending to them every day. But that fight is a super niche fight, and there's a couple of things that make all the difference on whether or not it's a $20 million life care plan or a $6 million life care plan. And knowing where to go with the fight with defense counsel on if it's going to be a nurse taking care of them or if it's going to be just an attendant who's an unlicensed nurse is quite literally everything for your client. It's the difference between getting the care they're going to need for the rest of their life and getting average care, getting lumped in with all the other brain injuries and going to be running out of money when they get older. So in this video, we covered a bunch of things. We covered how one of the biggest things I talk about all the other lawyers too is the limiting power of belief. If we don't believe in the case, you can't transfer that belief to others. The next is how to get all the evidence that you need to bring to bear to maximize the case value and figure out where the constraint is in the case, figure out how to get rid of that constraint so it can flow all the way through and you get the maximum value. And the last is the systems, because if you have the best fact you've ever had on your TBI case, but you write it on that note paper and you put it in a drawer, you don't have the ability to remember everything if you scatter your facts everywhere. And so Facts are only as good as the systems as you gather them and get them centralized in one place. And that's if you're the only lawyer working on it. There's multiple lawyers on the team, and I've worked with teams of, I want to say like 8 or 10 lawyers before. You need to be able to get all the facts in one place that everybody has access to. So it's belief first, then the evidence, then the systems to gather the evidence. You have to find the belief that made you believe the case was significant first, and then go gather significant more evidence about what gave you the belief. Because once you find what made you have the belief, that's not the only data point there. You can gather significant more about that data point, expand it, find the other areas of their life that it's affected, and then bring the systems together to make sure that when you're gathering all these facts, you're able to focus them down and then reveal the story that makes the impact that changes your audience in a way that they believe the way that you do. Once you do that, it's the way to maximize case value. So it goes belief, evidence, and then systems. And you put those three together, and that is how you maximize your case, and it's how you don't leave millions on the table with your TBI cases. I've talked about a lot of different resources in this video. I've talked about the TBI symptom checklist. I've talked about the work restrictions. I've talked about the activities and independent activities of daily living. I've talked about the TBI case audit. All of these are resources that we just give away. Figure out a way to get the information to your experts to make this epidemic of TBI cases. There's 1.6 million injuries that result in a TBI a year. We need to be the lawyers that help prevent that from causing more harm on the safety net.